As a practical matter, the due on sale clause is rather a paper tiger because the banks don't really have an interest in declaring loans to be in default and foreclosing on the due on sale clause just because ownership changes. It costs them money. Uh, if you're a lender and you've got these two rooms, the one over your left shoulder with all those good monthly paying mortgages, and the one over your right shoulder with all the ones that are in default and costing you money, what incentive do you really have to take a loan that's paying every month out of the room on the left and throw it in the room on the right just because the name on the land record's changed? It's going to cost you money to enforce the due on sale clause. You got to hire a lawyer, you got to foreclose. You run the risk of the person stopping payment if they're doing that. And thirdly, you've got to reserve, which is sort of a technical banking thing, but you've got to take money out of your lendable assets and put it in a sinking fund against the possibility that you won't get paid in full at foreclosure, and that reduces your profitability. So the net result is the banks have no incentive, in my opinion, to actually bring the due on sale clause into effect. It's a theoretical possibility, but in the 45 odd years I've been practicing law, as long as the loan hasn't gone into default, the only time I ever knew a bank to bring the due on sale clause into effect was in one very limited circumstance in the state of Maryland where the loan could only be held by a low income owner occupant. And the bank called up the investor buyer and said, we don't want to foreclose, we have to foreclose. But they talked about it, and the bank then misplaced the file for 60 days, and the investor refinanced, and that was that.
Right. So what you're saying basically is, from a bank's perspective, they would essentially, if they declare a breach of the due on sale clause, which most due on sale clauses, especially the big ones like the Fannie Mae, Freddie Mac, say that it's an option. The lender has the option, unlike your scenario where the lender had to. It's an option. So, but if the lender exercises that option, they're taking a performing loan and they're moving it from the performing loan bucket to the non-performing loan bucket. And then that hurts their ability to lend, because now they have, extra reserves, some downgrades, that go on. And now they can't make as many loans anymore, which, that's how they make their money, right? Is originating loans and collecting interest, right? So now all of a sudden you're harming yourself on a loan that was otherwise performing.
There's no really good business reason for doing it, in my opinion.
Right.
Now I'm not running one of the major banks, so you can't take it for gospel from me. But the other thing, of course, is that from what I've seen, a lot of these banks that collect loans don't own them. They're just doing the collecting work. Mm-hmm. And the loans themselves are owned by these loan pools or by insurance companies in these large, tranches. And they want a set rate of return. They don't care who is making the payments. And the servicing banks don't care. A, it's not their loan. And secondly, they get paid for doing servicing. Mm-hmm. So I think there's a disincentive there for them to think on any of the investors because it costs them business.